This lawsuit is brought to you by Firearms Policy Coalition. They are awesome. They've done a fantastic job. Texas lawsuit could blow a hole in gun-free zone laws across the country. The lawsuit is the Zingafus, I'm guessing is how you pronounce that.
Ziegenfuss.
Ziegenfuss?
I don't know.
I'm with you, either way, versus Martin. It's currently before the U.S. District Court of the Northern District of Texas. It challenges 3 separate carry bans covering establishments that derive 51% or more of their revenue from alcohol sales, racetracks or sporting events. So basically, and by the way, this is USA Carry did a great article on this out of Fort Worth, Texas. Also, this is brought to you by Prime Res. Prime Res is, they're wonderful. They've been sponsors, and Chris Wiley and Prime Res up in Alpine is absolutely wonderful. We love them to death. If you have any mortgage needs, you want to go to Prime Res. Prime Res out of Alpine can help you anywhere you are in San Diego County. Check out Prime Res, Chris Wiley. Not only do they support our show, but they will support you and help you get the mortgage that you need to buy your dream home in beautiful San Diego. So thank you, Prime Res, for the sponsorship. Basically, you can't carry in areas that derive 51% or more, or the majority of their revenue from alcohol sales or gambling, betting, that sort of thing.
Just can we clarify, though, this is Texas, not California?
Absolutely.
California presently is bars
Yes.
or restaurants. Okay.
Yep. This is out of Texas, out of North Texas is where the district is. It's actually the article, Fort Worth, Texas. A group of Texas gun owners backed by Firearms Policy Coalition is asking a federal court to strike down parts of the Texas Penal Code that prohibit the carrying of firearms in specific public venues. Talks about the lawsuit. At the heart of the case is the claim that Texas Penal Code 46.03 unlawfully infringes upon the Second Amendment rights of law-abiding citizens by banning licensed carry in common public areas that are neither secured by law enforcement nor historically considered sensitive places. So that sentence is actually becoming very, very important. In the past, currently, really, you're allowed to, the government's just been allowed to say, hey, this is a sensitive place. It just is. Trust us. And the new, I'd say, tactic for pushing back on this is to say, hey, wait a minute. Why, how do we define a sensitive place? What makes a sensitive place sensitive? If it is sensitive, are you protecting us in that place? Are there guards? Are they armed? Why is it sensitive? Why is a post office sensitive? Why is that a sensitive place? If it is a sensitive place, why don't they have armed security there? They don't think it's very sensitive, clearly, if no one's protecting this sensitive place. So that idea of places that are historically considered sensitive places that aren't secured by law enforcement, well, you're kind of losing your argument here that it should be a sensitive place. So why should a bar be a sensitive place? What's sensitive about a bar? If I go into a bar and I'm not drinking, and I don't drink, and I'm just there to have some ginger ale and a nice little cherry in my ginger ale and maybe a little, cherry juice and whatever. And, I shouldn't have to worry about carrying my gun, right? Why is that a sensitive area?
I have a question.
Yes, ma'am.
How do they define sensitive? Because I wonder if we are what do they mean by sensitive?
That's exactly.
Have they ever defined it?
No. That's exactly.
Okay.
That's kind of where the heart of it.
Is it vulnerable? Is it?
I know that the Bruin court did sort of say sensitive places include a couple of different locations, and it was like courthouses, legislative buildings, polling places. I think those were the only things in the Bruin decision that were considered sensitive.
But they didn't define sensitive.
No.
And if you look at those 3 places, polling places is really more of a First Amendment issue because they're basically saying, hey, this is sensitive. You can't carry a gun here because that it's like you're intimidating.
It could scare
somebody.
people.
Yeah, you're like you're intimidating people to vote a certain way.
Yeah.
But the other 2 places,
courthouses and legislative buildings.
So again, there's at least someone could understand, okay,
right.
Well, you might be intimidating a jury, you might be intimidating a legislator, but what do they have at courthouses and legislative buildings?
Yeah, they've got security.
They got security.
Armed guards.
So they can at least make the argument, that, hey, we have armed security here. There's
we're not letting you protect yourself, but we will protect you if needed. That's the promise-ish.
Yeah.
Not that we necessarily agree with that, but
I've told a story before about how I took somebody to the ER, and as they were getting checked in, security wanded me, and I said, "Yeah, I'm carrying a gun." And they said, "Do you have a badge?" And I said, "No, I don't have a badge. I'm not law enforcement, but I have a carry permit." And they said, "Well, I don't know what to do. Hold on." Got the supervisor. Now at this point, if I'm a criminal, I'm patiently waiting for them to get their supervisor.
Yeah.
Supervisor came in, was very polite, and said, "Look, you either need to put this into a locker that we have available for you. You can go back and put it and secure it in your car." And I said, "I'll go put it in the car." I noticed later that both of these security guards were unarmed,
yeah.
and I was like, "Well, wait a minute. It's got to be you or me. It can't be both of us
Yeah.
are disarmed. That's not safety."
It's safety theater. It's let's put on this production to make people feel good or to make people feel safe without actually providing any safety. And hopefully no one calls us out on it, and hopefully it doesn't become a problem. But I think about the liability that you would assume these businesses are taking on by disarming law-abiding citizens. Like, doesn't that feel like they would have some sort of liability if there was a problem in that building?
So that's where the fight is, and that's the point I really want to make in this. Even though it's in Texas and it may or may not directly affect California, that's the new battle of forcing them to define, well, what is a sensitive area and why? Why is it a sensitive area? And if it is a sensitive area, like you said, Dakota, isn't there a level of responsibility you are now taking on for our safety? And so, okay, so what's next? Court has set a May 14th date, so just a few days. It's less than a week away. That's the deadline for opposition briefs from both sides, followed by reply briefs due by May 28th. These filings will complete the summary judgment phase, after which the judge could issue a ruling without a trial. So summary judgment basically means, just like it said, if this case is strong enough, if the arguments are strong enough, if the opposition or support is so lopsided that it's so obvious, the judge could just decide, hey, I'm just going to make a judgment right here and now. We're not going to go any further. And that could happen. And I hope that we win. I hope that it is that strong in the eyes of the judge and they consider it a huge win. It talks about the national ramifications. The case is one of several post-Bruin lawsuits challenging state and local laws that restrict firearm carry in public spaces. At issue is the interpretation of what qualifies as a sensitive place, a category that the Bruin Court described narrowly to include courtrooms, polling places, and legislative buildings. This is the new fight, and we in California should be very, very supportive of what's going on in the other 49 states when it comes to fighting, because SB 2, just rake this over the coals. It was so offensively extreme when it comes to punishing sane, trained, law-abiding gun owners and where we can and can't defend ourselves. We got to fight back hard.
So I have a question, Michael. If let's say that this Texas case goes well, or any of the other cases that are similar, right? We've got sensitive place cases in California, New York, New Jersey, I think a couple other states as well. So for those states, if any one of those states has a case that goes really, really well for us, what does that look like? Does that look like it goes to the Supreme Court? Would that help determine those other state cases? Or is each state going to kind of make their own decision and then it's just going to stay at that level?
Good question. So it breaks down to, on the federal side, it breaks down to districts. Like we're in the Ninth Circuit, So anything that happens in all the other circuits doesn't really matter. The Ninth Circuit's kind of its own little fiefdom, and they can do whatever they want. One of the ways that people talk about getting to the Supreme Court is if the Ninth Circuit says, one thing, and then another circuit says another thing. Well, that's a reason for the Supreme Court to take a case.
It. Okay.
I think it's important. These lawsuits are crucial. We got to file these lawsuits, and every single district, every single person in every single district, we got to help them. We got to make sure that these lawsuits are filed. But the reality is the Supreme Court, like right now, we're frustrated that the Supreme Court isn't taking more Second Amendment cases, And the Supreme Court only takes a very limited amount of cases, and it depends on their caseload. If there's a, and the, fights between the executive branch and the legislative branch, that takes priority. So the more they're fighting, the fewer civil rights cases or Second Amendment cases they can take. And they really haven't taken a lot of Second Amendment cases historically over the course of, 250 years old now? So it's still crucial that we get the right people elected. We can't just sit back and wait for the Supreme Court to save us. But yes, that would be the ultimate. Firearms Policy Coalition emphasized that public carry should not be criminalized based on arbitrary classifications. Quote, the government cannot designate common public places off limits to peaceable armed citizens just because it disapproves of where people gather. I think that's a powerful statement.
Yeah, I think one thing about this argument that's always interesting to me is you hear the other side say things like, well, if it's a gun-free zone, it would be horrible if we are arming these people. I hear it a lot with schools. They're like, oh, well, this is a gun-free zone, but now you want to arm the teachers. And it's like, I don't think anyone here is arguing for arming people who don't want to be armed. We're just saying stop taking away the guns from people who would otherwise be carrying a gun everywhere they go. They're already carrying a gun. They're going to all of these places, but now you're actually telling them they have to disarm themselves to be there. And that's the piece that we're against. We're not saying everybody in a bar should carry a gun. We're saying if you already were going to be carrying a gun, we should not be forcing you to take the gun off just to go to the bar.
There you go. Exactly right. Hey, thanks for watching Gun Owners Radio. I hope you loved that clip. Don't forget to like, subscribe, comment, and follow us on social media, and check out our website at gunownersradio.com.